Good afternoon, and thank you for joining us for our webinar, Is the ACA Invalid? Learn about the recent federal court decision. Hello, my name is Julia Goebel, Chief Marketing Officer of Benefit Express. I will be your moderator today. A few housekeeping items before we get started. If you missed something, don't worry. We'll be emailing you the recording with the slides after the webinar concludes. I'll be keeping the webinar muted to avoid any background noise. And we'll pause throughout the webinar and at the end for questions. Simply type your question in the box in the GoToWebinar screen, and I'll read it aloud for you. And if we don't get to your question today, because we know there are many questions, we will be sure to email a response as a follow-up. Now I'd like to introduce our speaker. ERISA attorney Larry Grugin is our presenter. With more than 35 years experience in employee benefit law, Larry has a wealth of experience in dealing with qualified plans, health and welfare, fringe benefits, and executive compensation areas. Thank you for joining us today, Larry. We are thrilled to have you. And with that, I will now hand it over to Larry to discuss the topic that's surely on everyone's mind. What does the recent federal district court decision mean for ACA compliance? Take it away, Larry.
Thank you very much. When this was announced in December of 2018, everybody called me and said, well, does this mean we have to comply with the ACA anymore? Because it was advertised the fact that this judge had declared the ACA to be invalid. And I started looking at it, I read the decision, and right now, and you're going to see this during the presentation, there's no injunction stopping the compliance with ACA. What I'm going to try to do today is discuss these three questions, and this is extremely important. First of all, what was decided? And I'll be talking about, they centered on the individual mandate, then they went on to the general ACA. And the next question is, what was the basis for the decision? And this is going to be interesting to understand, because the fact that that's going to, and understanding that is what will happen in the future. Is there any valid basis for their decision? Is it going to be easily overturned? And we won't know that in the coming months because it's going to be appealed to the Fifth Circuit. So it's going to be a while before this comes up to the appeals court. And then what will happen as a result of the decision? What do you have to do in the next few weeks or months? I'll be talking about that. I'll be talking about what the impact of this is. Just as a side note is that the government has said that until it's decided, they will continue to enforce ACA. So those of you who are getting inquiries over the last few months in regard to the 1094s, 1095s, you can't ignore those. Those will continue. So all aspects of ACA will continue until this decision is decided by the Fifth Circuit, and probably it will go to the Supreme Court. So it's going to be a while, and I predict it may be not until 2020 until it gets to the Supreme Court. So it's going to be a while before we see exactly what happens. So throughout the presentation, if you have any questions, they'll stop me. I'll answer any questions. So it's extremely important to understand for yourself, your clients, and your employees, understanding exactly what the impact is. So the first thing we're going to talk about is what was decided by the court. And what the judge found, this was decided on December 14, 2018. Judge Reed O'Connell of the Fifth Circuit District Court for the Northern District ruled that the Affordable Care Act is unconstitutional and therefore invalid. And what they centered on is the fact that they felt that the individual mandate, since it was changed in 2017 by the new Tax Act, it's no longer a tax, and therefore so the individual mandate is invalid, and because that's invalid, the whole thing falls apart. Now, what happened in this situation, the lawsuit, Texas versus United States, was commenced by 19 states. These are the attorney generals of 19. These were mostly Republican attorney generals and 2 individuals. So that's who brought the suit. And basically, they sued the United States, contending that now because of the changes, the ACA was now invalid. Now, defending the ACA was intervener states. These were Democratic attorney generals joined the litigation to defend the ACA. Originally, the federal defendants were the United States, HHS, and IRS, but the Democratic attorney generals had to come in and defend the individual mandate, as this slide indicates, because though they did not defend the individual mandate constitutionality. And they felt that even though, what they argued though, even though the individual mandate may be unconstitutional, it could be severed from the rest of the ACA provisions. So they wanted something to survive. All right. So as it goes to the courts, one thing that's extremely important to understand is if this decision by the Fifth Circuit in Texas is upheld, what will happen? We'll hearken back to March 23rd, 2010, and March 22nd, before the ACA was passed. So if this is found to be if the ACA is found to be unconstitutional, it will eliminate, as the slide says, not only the marketplaces, but the Medicaid expansion, the premium subsidies, the employer mandate, any other provisions that were in place under ACA are going to be wiped out. Now, when is it going to be? If it's upheld, it's probably going to be wiped out beginning in 2019. So they're not going to go all the way back to 2010 or 2014, when some of the different provisions became applicable. So it's going to wipe out any pre-existing condition protections are gone. Any changes in regard to mental health parity, Addiction Equity Act, the Medicare Part D donut hole, all that was as part of the ACA are going to be eliminated. And in essence, the exchanges would be gone, because any part of the ACA would be eliminated if this decision is upheld. So this is a huge deal, and that's why everybody is looking at this, because if it is upheld, the impact is going to be dramatic. So what are some of the provisions? So basically, what Judge O'Connell reached 3 different conclusions. First of all, they held that the plaintiffs had standing to sue. In other words, they were injured, and they have a right, because of the injury, to sue to recover. So they found that the plaintiffs had a standing to sue. And secondly, what they found, that the individual mandate is no longer permissible under the Congress's taxing power and is unconstitutional. What they found is, once in December of 2017, the Congress had changed the individual mandate to keep it in place, the individual mandate, but the tax is now 0. So the requirement is there, but there's no penalty. There's no tax anymore if you don't obtain any coverage. And harken back, and I'll be talking about this, in 2012, the Supreme Court upheld the individual mandate because they felt that it was a tax, and the Congress doesn't have the power to force someone to buy something, but they do have the power to tax. And since the Congress in 2017, under the Tax Act that was passed in December of 2017, eliminated the tax, therefore the basis for the individual mandate goes away. And that's the whole argument. Now, the third conclusion is extremely interesting. The court found that the individual mandate is essential and inseverable from the entire ACA, meaning that the entire law is declared invalid, which means that if you're taking a piece out of the law, and the judge said since the other pieces relied on the individual mandate, everything falls apart. That's what the judge's conclusion is in this situation. So these are three important decisions that the court found.
Larry, I want to share a question from our attendees.
Mm-hmm.
Mary asks, I don't understand how one court's decision applies to everyone. Can you talk about the appeal process and how it arrived at the federal district court?
Well, again, every federal district court has the power to decide federal law. As you saw a few days ago, Trump tried to do something, and basically what happened was the court said, I can't remember exactly what he tried to do, and the district court, again in this situation, now well, what can happen? What can happen? Somebody else can sue in another district, and sometimes the decisions are only applicable to states in that district. In the 5th district, I think, is Texas and a few other states in that area of the country. But many times they'll do an injunction that is nationwide, so the judge has that power to do so. Now, in this situation, you'll see in the next few minutes, the judge decided not to do an injunction. And basically what the judge did, that they stayed that decision, his decision. So right now, whatever he decided is in place pending the appeal to the 5th Circuit Court of Appeals. So right now, this does not have, and because it's federal law and it applies to many states, that's why it has this effect. Okay, so that's the reason for it. So if it's invalid in Texas, then it's invalid across the country. So federal law has the effect. Now, sometimes what may happen is that some other people go to another district, file suit in another district, and then if a second district decides the opposite way, then automatically that is appealed to the Supreme Court. So again, people that support the ACA may end up doing that to the 9th Circuit, to another circuit, and get another judge to say, no, that judge is wrong. The ACA is valid. The individual mandate is valid. And then in that situation, it will if there's a conflict between the two districts, then it would be immediately appealed to the Supreme Court. What could happen here? What could happen here is that it goes to the 5th Circuit Court of Appeals. The 5th Circuit could say, yes, we agree with the judge. It's appealed to the Supreme Court, and the Supreme Court will say, we don't want to hear it. We'll let the Court of Appeals decision stand, and therefore, in that situation, then it would apply to the rest of the country because there's no conflict in other districts. Now, what some people may do is then sue in another district, get another judge to say something else. If there's a conflict, as I indicated before, then the Supreme Court has to take it. And that may happen. That may happen. So one thing is important to understand. The Congress has limited authority. And if so, if Congress is to act constitutionally, it must have found a basis and to do so in the Constitution. And the Supreme Court case, the NFIB case, the Supreme Court in 2012 upheld the constitutionality individual mandate by indicating, and this is Judge Roberts indicated this, that the individual mandate imposed a tax on those who did not buy ACA approved insurance. And the majority of the Supreme Court said that's a valid exercise of congressional authority. They can levy taxes. But what the Supreme Court said is that if it wasn't a tax, what they said is that the government cannot force someone to buy something. That's not in the congressional authority to do. So in 2012, the individual mandate was declared constitutional because it was a tax. So at the time, the Solicitor General, arguing on behalf of the Obama administration, argued that the individual mandate was inseverable from the prohibition of pre-existing condition exclusions, meaning the court were to deem the individual mandate unconstitutional, other provisions of the law would likely be struck down as well. So this argument was saying, if you do this, then the whole thing that we did in 2010 is gone. And what the judge did in the decision cited various different individuals in the Congress, in the Obama administration, and at various divisions of the federal government that said this individual mandate is extremely important, and if that goes, then every aspect of the ACA goes. Now, what's interesting, in 2017, under the Republican Tax Act law, known as the Tax Cuts and Jobs Act, Congress reduced the individual mandate to zero. So they did not eliminate the tax. They just said, if you don't get any insurance now, the tax is now zero. And therefore, so what the district court indicated, the whole constitutional basis of the individual mandate goes away, and therefore it's unconstitutional. So let's go in a little deeper in the basis for the decision. So the Constitution's taxing power cannot, after the tax cuts law, eliminate the tax to be used to make the ACA constitutional, because a tax is not a tax unless some revenue is generated. If no revenue is generated, then it's more of a penalty. So in 2012, the majority of the Supreme Court in that decision said that the Constitution's Commerce Clause, and this is where Congress gets its power to control commerce across various states, does not extend in mandating the Americans buy products. So there's no constitutional underpinning for ACA after the taxing power is irrelevant by virtue of the changes in 2017. So the Supreme Court said that Congress cannot force people to buy stuff. Now, people argue, well, how about the fact that they force you to buy insurance, auto insurance? Well, that's a state issue. The state has different powers in the Congress. They're saying that Congress cannot force people to buy stuff. And I look at this and I said, well, how about, I think of two other things that we are forced to buy. We are forced to participate in Social Security and Medicare. Our paychecks are deducted every month. And again, maybe the argument there, that's more of a tax, anything else, but they're still forcing you to participate in Social Security and Medicare.
So Larry, I think in that slide you've answered a question that came from our listeners, which was, if the individual mandate was not removed, but the penalty was reduced to zero, why are they proceeding? Simply because, as you've noted, it's part of the strategy that's being.
Well, it's still there. I mean, and who knows? And the argument is from the other side, who knows what the federal government's going to do? Are they going to force people to buy insurance because that individual mandate is still there, even though there's no penalty involved, the requirement to buy insurance is still there. Now, my argument here is the fact that the individuals that sued, where's the harm? And they would argue the harm is, as I indicated, the individual mandate is still in place, and we don't know what the federal government's going to do in the future to enforce that requirement. And I think that's the issue. But again, in order to sue, you have to show injury. And where's the injury by having the individual mandate stay in place by having no tax? Where's the injury? I think that's the argument. So here, Judge O'Connor ruled on a summary judgment the ACA's individual mandate was no longer constitutional because no longer tax, but did not enjoin the federal government from enforcing the non-individual mandate aspects of ACA. So he made a ruling, found that the individual mandate was unconstitutional, the ACA was invalid, but what he didn't do, saying, federal government, stop what you're doing. And what he basically indicated, I will hold off in issuing an injunction to the federal government and until you file an appeal to the 5th District Court of Appeals. He has the power to do that, but he hasn't done it yet. And again, as I indicated before, if he does that, then I would think individuals that support the ACA will then go to another district, force and ask another judge to stop this judge, and that happens then. If there's a conflict between two judges, then it will be automatically appealed to the Supreme Court. So in the different various bases for this, the standing, as I said, a collection of 19 attorney generals and 2 individuals sued. The District 4 found that the plaintiffs had standing because the individual mandate was still in place. But, and this is going to be very interesting, the Supreme Court requires injury, in fact, to sue in federal court. And it's going to be interesting if they've come up with some kind of injury. And I think the argument is going to be, well, the individual mandate is still in place. We don't know what the federal government's going to do in the future. They may force us to do something else. So if that Tax Act in 2017 removes any possibility of tax penalty, the bigger question is, well, where's the injury? It's sitting out there, but what can the federal government do to enforce it? That's the issue. So in the past, the Supreme Court agreed that Congress didn't have the authority to require individuals to engage in a private transaction. And this is the 2012 decision. In the view of the court's majority, Congress created a tax on those who refuse to purchase health insurance. Absent the penalty, the failure to purchase health insurance, the plaintiffs argued, the law was no longer an exercise of the Congress's taxing duty and therefore should be assessed under other constitutional congressional powers. And since the Supreme Court in 2012 said that the Congress cannot force people to buy a product, therefore there's no basis for the individual mandate. So the federal court agreed, finding the post-Tax Cuts 2017 ACA mandate to be unconstitutional. Now, as I indicated before, and this is extremely important, the individual mandate is essential to and irrevocable from the entire ACA, meaning the entire law is declared invalid. And the court held that its unconstitutional mandate cannot be severed from the rest of ACA. Citing the text of the law itself, the Supreme Court decisions describing the individual mandate as being essential I also took comments from various members of Congress and also the Obama administration when this was passed, to use it as a way of proving the fact that since the individual mandate is essential, it cannot be separated from the rest of ACA. If that goes down, the rest of the law goes down. So the court determined that the individual mandate is essential to and must work together with the ACA's larger regulation of the healthcare market. So without it, they're arguing, the whole thing just falls apart. Now the question of the hour is, what happens next? The judge has refused to order an injunction, which means it stays in place. So in December of 21st of 2018, the plaintiffs and the federal government asked the judge to allow an immediate appeal to the Fifth Circuit. That means all parties to Texas, plaintiffs, federal government, and also the intervener states, which is the Democratic ACE, now agree that Judge Connell should certify the decision for an appeal and stay any additional proceedings while this case is on appeal, which means that everything holds in place. Nothing happens. As this thing goes to the courts, goes to the Fifth Circuit. And the federal government and the Democratic Attorney Generals encourage the judge to conform his decision, does nothing to disrupt the ACA, and the ACA remains the law of the land. So again, the judge has said, we're not going to do anything more than this. Even though I've decided against this, the federal government, I'll let this stay. So again, the Democratic Attorney Generals asked whether the order was immediately binding. In response, on December 30th, 2018, the court said yes. They entered final judgment on the December 14th order, issued a stay on that order saying, yes, I've decided that the individual mandate is unconstitutional, ACA is invalid, but I'm not going to enforce it and force the federal government to act. I'm going to stay that. That means we're not going to do anything else. So the court issued an order staying there any remaining claims in the litigation. So it stays in place. The ACA stays in place. After the decision was reached, the Trump administration has announced it will continue to enforce the ACA, notwithstanding judge's decision. And so therefore, and this is a surprise to everybody, Texas versus United States has changed nothing. Now, in looking at this, I think what's going to happen here is that I think it's going to be, it's already appealed to the Fifth Circuit. The Fifth Circuit could take a few weeks or months to decide. And remember, the Supreme Court, they are in session to the end of June, and then they go back up in October. So I'd be very surprised if the Fifth Circuit has decided this and bounce it back to the Supreme Court by the end of the current session. I think the Supreme Court will, if they're going to take it up, will take it up starting in October of 2019, and I would suspect there may not be a decision until sometime before June of 2020. In the meantime, on June 3rd, 2019, the intervener states, which means the Democratic ACA's attorney generals, challenging appeal to the Fifth Circuit. Now, since the House of Representatives in the Democratic hands, they submit a motion to intervene in the litigation as plaintiffs' claims other than count one. And in accompanying filing, the court set out basis for intervening and defending ACA. So now the House of Representatives now is getting to the act and will probably file various filings with the Fifth Circuit Court of Appeals. The House acknowledged they could not intervene on count 1 because the intervening state's notice of appeal, but on January 4th, the DOJ requested a stay on the briefing concerning the opposition to the House's motion because of the shutdown. DOJ's response was due on January 17th. It was asked for the court to delay it, and the court granted the delay on January 11th, saying any response to the House's motions are not going to be due until 10 days after the shutdown ends. So, what does this mean? It means that the Congress has a little over a year to act. If they're going to fix the ACA before the Supreme Court rules on this, something should be passed during 2020. We don't know what the Fifth Circuit Court of Appeals is going to do, and people have asked me, what is your read on this? What do you think is going to happen? I think it's a 50-50 chance. Either way that the Court of Appeal rules, whoever loses that Court of Appeals decision is going to then petition the Supreme Court to take up the case, and whether the Supreme Court does pick up the case is another matter. But if they don't, then what's going to happen, as I indicated before, they may, for example, the supporters of the ACA loses in the Fifth Circuit, what they may do is file another case in the Ninth Circuit, find a judge to stay this. And if there's a conflict between the districts, as I indicated before, then the Supreme Court has to take the appeal. So that could happen, and that will drag that out for a longer period of time. So stay tuned. Stay tuned. So I think there's a 50-50 chance. I'd be very surprised if this is decided in 2019, but it could. But again, there's going to be more court actions. There could be other districts involved in this. So this is going to be interesting to see. But again, the district court judge has not issued a stay on this, so we stay in place until we see further action from either the Fifth Circuit Court of Appeals or from the Supreme Court. Are there any questions?
Hi, Larry, you bet. We've had some terrific questions coming from the audience. So I want to start with one that I think has a big impact for many employers on the phone. This one comes from Donna F. And her question is, can the law be modified to make the individual mandate severable from the rest of the ACA? If there's no penalty, individuals will not be insured, but all the good from the ACA, preventive, biosimilars, et cetera, removal of pre-existing conditions all go away, and that will have a huge impact on individuals.
What they would have to do is pass a replacement to ACA. And looking at what's happened over the last 3 or 4 weeks, the chances of the Congress passing anything is next to nil. I think it's going to be because in order for this to happen, there has to be passed a replacement to ACA containing those elements of the ACA that everybody agrees to are good. But whether that's going to happen, because then both sides are going to push the envelope. I want this, I want that, I want this removed, I want that removed. And right now, both sides are dug in. And whether anything can pass this Congress is an open question. And again, the problem is, if the Supreme Court decides the ACA is invalid, I think that's too late to act. Congress has to act over the next 6 to 9 months to get anything that there's a compromise on. I think that's what's important.
Very good. Here's one that may test some of the technical limits. I want to chat this to you so you see it in writing and also read it to you. If a company uses a 12-month look back, does its employees have to work both 1,560 hours and every month of the measurement period to meet eligibility?
See, this sounds like gobbledygook, but I understand what the question says.
They
And basically, anytime you have variable hour employees, for those of you who do understand this, remember that when the ACA was passed, and there are under ACA, there are 3 types. For the employer mandate, there's 3 types of employees. There's part-time, full-time, and variable hour. What they're referring to right now is variable hour employees. And the Congress said as part of ACA, okay, for variable hour employees, and these are employees whose hours are not always 30 hours. They may work 20 hours, no hours, 1 week, whatever. Basically what the employer can do to determine, because remember under the employer mandate, you're supposed to provide coverage to full-time employees. And for certain industries like restaurants, hotels, nursing homes, there are many employees that don't work a steady shift. Depending on demand, they could work 50 or 20 or none. So to do this full-time employee calculation, you can set up what's called a look-back period. You look back to see how many hours. And the look-back period can be a period of up to 12 months. If you have 12 months, then basically what you can do, that 130 hours per month times 12 is 1,560. That's why 1,560 is mentioned there. Basically, in this calculation, we don't look at every month. We look at the total at the end of the period. So you don't have to work every month. As long as you're an employee and you're working, at the end, we look back at the end of the measurement period. If you have 1,560, going forward, you are considered to be full-time, and you have to be offered coverage. So that's what's important to understand. That is that is probably the most complicated section of ACA. It's causing all kinds of issues and problems for certain industries because the employer has to go through this calculation. Okay. I know it's clear as mud, but
no, I think that actually covers it well. The next question comes from Kevin. Will 1095-C filing be due for 2019 in early 2020?
Yes. Now, what's going to be interesting for 2019, because of the change in the individual mandate being 0, whether they're going to require the 1095-B and whether they're going to require a question on the 1040 asking if you have coverage. So that's an open question right now. So the 1095-Bs and 1095-Cs that were in existence in prior years may be changed because of the Tax Act of 2017. So let's see what happens, how the federal government deals with the individual mandate staying, but the tax being 0. How are they going to enforce that? That's the question.
And that remains an open question.
Yes.
I'll ask our audience if we have any further questions. I have one more in the queue, but this would be your opportunity to raise anything for Larry before we wrap up in just a few minutes. Once again, if you would like to ask a question, you can use the area, the Go to Webinar section on your screen. Here's one from Charlotte L. Charlotte asks, I am a school district. When completing our 1095-Cs for a non-calendar year renewal, why can't the IRS tell me when the measurement periods are for Part 2?
Well, see, you have to determine that. The measurement is determined by, because everything, just like a W-2, everything on the 1095-C is on a calendar year. But what you can have a measurement period that it isn't a calendar year. And again, because the new employees, they're going to drop in during the calendar year. So the IRS can't tell you because it's something, the measurement period is decided by the employer, and many times the measurement period for many employers is going to be cognizant of or in relation to your renewal on your insurance. So if you have a non-calendar year insurance policy, what you want to do is determine who is full-time at the start of that policy year or plan year. So that's something you have to decide as an employer.
Okay, very good. This one comes from Al M. Al asks, are audits limited now due to the federal shutdown?
I didn't hear the first part of it. I'm sorry.
Yeah, he's wondering, are audits limited presently due to the federal shutdown?
There are many IRS auditors that are on a furlough.
Mm-hmm.
So I've tried to send faxes over there. I've tried to call them, and you just get a message over and over again. So I don't think that many people are there. I think there's some IRS employees processing refunds, but it's my understanding that there's really no audits being conducted right now.
Very good. Thank you. And this is a follow-up question. In general, have you seen audits for groups under 100 FTEs?
Yes. Various things will trigger audits. The most popular reason why you are being audited is probably from a disgruntled, it's either at random or it's a disgruntled employee that's complained to someone at the government. Those are the two reasons why under 100 are generally audited. So treat your former employees nicely because they could cause you all kinds of problems.
That's good to know. And in general, treating employees well, whether they're coming or going, probably is a good long-term policy. Here's a question from Amber R. Amber asks, we have some employees that change from full-time to variable. We extend medical, but they say they don't want it. Is this okay?
In this situation, the problem in this situation is if you have somebody going from full-time to variable, and if you haven't measured them, the law says that basically what you have to do, you have to then use the monthly measurement method, not the look-back method, and you have to wait a period of time before you can terminate their coverage. So that's the problem. And remember, if you have a variable hour employee, it's another question, and their hours are reduced, and they've in the past decided to accept coverage. Remember, during the stability period, which is the coverage period, that employee is considered to be full-time. No matter how many hours they have, they are considered to be full-time. The only time they can drop coverage is during the open enrollment for the exchange. You can allow them to drop coverage to go on the exchange. But again, the only way an employee can drop coverage is not to pay the premium. And if they do that, the problem in doing that is if they don't pay the premium, it's not a COBRA qualifying event. So they're stuck. If they decide later in the year they want coverage, that's the problem.
Thanks for that. So here's a question from Kevin. When will penalties for 2016 and 17 be sent out, in your opinion?
Well, a number of my clients have gotten penalties already for 15 and 16. I have not seen any penalties come out so far for 17. So I haven't seen that. There was a rash of letters that came out in November and December for 2016. Because of the shutdown, I think those 17 letters are going to be delayed, so you won't see them for a few more months.
Very good. And on a 2018 1095, would the measurement period ever go back to 2016?
No. The longest measurement period is 12 months. So you just have to keep on repeating. And remember, there's two types of measurement periods. There's a measurement period for ongoing employees, another one for new employees. And so you just have to make sure you keep all that stuff straight. But it's a rolling period that keeps on year after year after year. And especially for new employees, you have to drop them in the middle. There's what's called an initial measurement period and then a ongoing measurement period or standard measurement period. So you just have to make sure you get that right.
Very good. And this looks like this will be our last question. Here's an example of a 90 FTE client employer. If an employer offers insurance but does not pay for the plan, is the employer only liable for the B penalty?
Well, if you waive coverage and the coverage is not affordable nor minimum value, the only time you're going to be penalized the B penalty is if they go and get a credit or subsidy. So only if they get a credit and subsidy will the employer be penalized. But if you offer them affordable minimum value coverage and they waived it, then the employer has no penalty.
Great. So I think that answers that question well. And then a few people have asked, how do we access the webinar information or receive copies of the presentation? We will be providing a recording as well as a copy of the slides. We're glad to hear that this was useful to everybody, and a few of you chatted that it had a number of really good legal summaries for non-legal audiences. So kudos to you, Larry, for that.
That's my contact information. I have a newsletter, comes out 3 to 6 times a month. If you want to go on the newsletter, it's free. I don't charge for it. And I follow developments on a daily basis. So thank you for having me, and I appreciate it.
Great. Well, thank you, everybody. This concludes our webinar for today. Enjoy your afternoon.
Bye-bye.